On October 17th, a 5-judge constitution bench of the Supreme Court of India, exercising judicial restraint, unanimously refused to accord legal recognition to marriages between the persons of the same sex. Also, in a split vote of 3:2, the bench ruled against the civil unions and granting adoption rights for non-heterosexual couples. The court has effectively passed the ball into the legislatures and the executive's court to decide on the matter. Given the progress in the law in the recent years and the deepening of the meaning of individual rights, the ruling is considered as a huge legal setback to the queer community of the country. Before dwelling into greater details on the various aspects of the recent ruling, let us first try to understand the background in which the recent petitions were filed. We will also have a look at the progress made on the protection rights of the LGBTQIA+ community. The first major development in the recognition of rights of the community came in 2014 when a 2-judge bench of the Supreme Court in Nalsa vs. Union of India case legally recognized non-binary gender identities. The court in this case upheld the transgender person's right to decide their self-identified gender and directed the state to grant them legal recognition through progressive interpretation of the Article 19 and 21 of the Constitution. The next chapter in this story was Section 377 of the Indian Penal Code. It considered carnal intercourse against the order of the nature and made them a punishable offence. However, in 2018, in Navtej Singh Johar vs. Union of India case, a 5-judge constitution bench unanimously struck down the Section 377 of the Indian Penal Code. This judgment also marked the reversal of the Supreme Court's stance on Section 377 in Suresh Kaushal case of 2013. Further, in the famous right to privacy verdict in the Justice K.S. Puttaswamy case, a 9-judge bench of the Supreme Court held that the Constitution protects the right of a person to exercise their sexual orientation. However, despite these judgments and the enactment of the Transgender Persons Act in 2019, the court observed that the members of the transgender community continued to be denied equal citizenship. Amidst this background, a petition was filed in the Supreme Court for legal recognition of marriage and rights of adoption, among others, for the LGBTQIA+ people. Having understood the background, let's try and decode different issues raised by the petitioners. The main petitioners, Supriyo and Abhay Dang, argued that non-recognition of same-sex marriage amounted to discrimination that stuck at the root of dignity and self-fulfillment of the LGBTQIA+ couples. The petitioners sought enforcement of the fundamental rights of choice of partner and declaring that the Special Marriage Act of 1954 to include solemnization of same-sex marriage. They argued that non-recognition of same-sex marriage violates rights under Article 14, 15, 19 and 21 of the Constitution. Moreover, the exclusion of the LGBTQIA+ couples from the legal regime on marriage also excludes them from the legal regimes protecting families and host of other legal benefits enjoyed by married couples, including the right to wages, gratuity, surrogacy, among others. In a related vein, the Delhi Commission for Protection of Child Rights stated that the same-sex couples would make equally good parents as heterosexual parents. However, the union government has said that the idea of same-sex marriage is merely an urban elitist view. The judicial creation of a new social institution like same-sex marriage cannot be claimed as a matter of right. It is the parliament and not the courts that have to decide on the same-sex marriages, which is a threat to the holy union of marriage between a biological man and woman in India. Additionally, the National Commission for Protection of Child Rights, unlike its Delhi counterpart, argued that the same-sex marriage would violate the provisions of the Juvenile Justice Act 2015. It cited the emotional problems suffered by the children of same-sex couples based on a study by the Catholic University of America. Having understood the various issues raised, the court ruled on three major aspects of marriage, civil union, and adoption. Firstly, on the issue of marriage, the court unanimously declined to strike down the constitutional validity of the Special Marriage Act 1954 or reading words into the act. These being matters of policy, court expressly left it for the legislature and the executive. The court, however, ruled that transgender persons in heterosexual relationships have the freedom and entitlement to marry under the existing statutory provisions. Additionally, the minority judgment written by the Chief Justice of India also stated that intersex persons who identify as either male or female have the right to marry under existing law, including personal laws which regulate marriage. Further, on the issue of marriage, the CJI observed that the Constitution does not expressly recognize a fundamental right to marry. He also recognized that there is no universal conception of the institution of marriage, nor is it static, and that the state has an interest in regulating the intimate zone to democratize personal relationships. On the issue of civil union for queer couples, there was a disagreement within the bench. While the Chief Justice of India, D.Y. Chandrachud, and Justice S.K. Kaul called for a recognition of queer civil unions to ensure that queer couples could get material benefits flowing from a marriage, a different view was taken by the other three judges on the bench. Before we go any further, let's first understand what a civil union is. A civil union is a legal recognition originally created for same-sex couples in jurisdictions where they are not legally allowed to marry. It grants rights similar to those of marriages and was first legalized in 1999 in the state of Vermont in the United States. It is basically a halfway approach between non-recognition and full recognition to homosexual marriages. The Chief Justice of India located the right to form intimate association within the Article 19. He further observed that the right to enter a union cannot be restricted on the basis of sexual orientation, which would violate the Article 15 of the Constitution. Moreover, marriage is significant because of a bouquet of rights, and for the same-sex couples to enjoy these entitlements, it is necessary that the state accords recognition to such relationship. The majority opinion written by Justice Bhat, however, disagreed with the view that the court can prescribe a choice of civil unions to queer couples. He also stated that the government is not obligated to recognize the bouquet of rights flowing from such a union. This brings us to the third aspect of the judgment, adoption. On the issue of adoption, there was again disagreement within the bench. This aspect is centered around the Regulation 5 Clause 3 of the Adoption Regulation, which have been framed by the Central Adoption Resource Authority in the year 2022. The Regulation 5 Clause 3 allows only a couple who have been in at least 2 years of a stable marital relationship to adopt. Individually, as per the observations in the judgment, queer persons can adopt as single people. However, a single male is not eligible to adopt a girl child, even though a single female is eligible to adopt a child of any gender. The Chief Justice of India, in his minority opinion, declared the Regulation 5 Clause 3 as ultra vires of the Juvenile Justice Act 2015 and Articles 14 and 15 of the Constitution. He further read down the Regulation 5 Clause 3 to exclude the word marital. The Chief Justice of India also observed that the exclusion of same-sex couples from adopting has the effect of reinforcing the disadvantage already faced by the queer community. The law cannot make an assumption on good and bad parenting based on the sexuality of individuals. He also held that the government has not proved that precluding unmarried couples from adopting is in the best interest of the child, which is the guiding principle of the Juvenile Justice Act. The majority opinion, however, refused to strike down the Regulation 5 Clause 3, citing it would be not in the best interest of the child. The bench, however, reiterated the need to strengthen sensitization about queer relationship, noting that the children of same-sex couples face stigma due to the inherent biases that society holds against queer communities. It also, in principle, agreed that a couple tied together in a marriage are not a morally superior choice or per se make better parents. Before we conclude, let's have a look at the global situation on the issue. Currently, there are more than 130 countries across the globe that have decriminalized homosexuality. Further, the Netherlands was the first country to legalize same-sex marriages in 2001. Since then, more than 30 countries around the world have followed the suit, with most being from Europe, North America and South America, including Australia and New Zealand. Though the recent Supreme Court judgment came as a disappointment or at least a setback for the LGBTQIA+ rights, particularly in the context of marriage and adoption, the assurance by the Union government to constitute a committee under the chairmanship of Cabinet Secretary gives a ray of hope. In this regard, the Chief Justice of India's suggestion to include experts with domain knowledge and experience in dealing with the social, psychological and emotional needs of persons belonging to the queer community as well as the members of the queer community should be followed by the government. The committee must have a clear time frame and locus of authority for effective functioning. The whole episode is a reminder that societal progress often takes time and the path to change is seldom straightforward. This judgment has certainly stirred up debates on legal recognition and civil unions of the same-sex couples. While there are differing opinions, the struggle for equality continues.